number 1, the people of the state of New York versus Gregory Vining. Counsel?
Good afternoon. Margaret Knight from the Office of the Appellate Defender. If I might have 2 minutes for rebuttal, Your Honor.
You may.
By Gregory Vining's 2012 trial, the District Attorney's Office made more than 10,000 requests per year for Rikers Island telephone calls. With every call, detainees are repeatedly told that their calls are being monitored, and one of the first things that attorneys tell their clients at arraignments is not to talk over these telephones. Yet when Mr. Vining refused to talk, his silence was used as an admission.
Was he really silent, though, counsel? Didn't he actually speak and say some things that tended to turn the conversation toward his sentencing rather than his former girlfriend's injuries?
He certainly made some statements, but none of them were an acquiescence or indicated in any sense that he was adopting what she was saying. And this case was litigated throughout as an adopted admission by silence. That is what the prosecutor argued to the court that it was being admitted for. That is what the court instructed the jurors that it was being admitted for. And that is what the First Department found that the statements were admitted for. So this case was about his silence. And this.
But have we ever applied the Eighth Amendment to situations where it's a conversation between two civilians?
This court has not, but I think that the Rikers Island telephone calls represent something that this court really does need to speak on in this context. And it wasn't just between two civilians, because these calls are being monitored and they're being recorded and they're being provided regularly to the government. So even though the conversation was between two civilians, like defense counsel said at trial, it might as well have been made with a police officer sitting there.
But should we consider the fact that the defendant initiated the call and apparently for the purpose of pressuring his domestic violence victim to not pursue the charges against him? So in essence, it appears that rather than using the Eighth Amendment as a shield, he's really, in effect, using it as a sword. Should that be a consideration?
That is, I mean, as the district attorney office noted, there were about 25 calls between these two people, and they didn't just talk about her injuries. The vast majority of times they must have been discussing something else, and in fact he was also asking if she had spoken with his brother. They were talking about where he would live. So I mean, this for Mr. Vining, but also stepping back for so many New Yorkers, these telephone calls are a lifeline to the outside world for detainees who have not been convicted of anything, who are the poorest New Yorkers, who cannot afford bail. And these phone calls are how they communicate with people, and you're really putting people in sort of a damned if you do and damned if you don't
So
kind
it
of
should be one rule. You can never do this, or is this a case-by-case analysis for us?
I think the categorical rule of Conyers and DeGeorge should apply. At least this court has generally said that silence post-arrest should not be used in a direct.
All of those cases, as I read them, involve some type of involvement by law enforcement. Now, we had a recent case on the Sixth Amendment. It was different with Rikers Island tapes, where we said it wasn't a violation of the Sixth Amendment. It seems to me here, isn't this a discretionary call for the judge? I mean, it's a private party calling up another private party, I think in violation of a restraining order here, if I'm not wrong, and having this conversation. Is it really the fact just that it's a Rikers Island over here that would make it, what, a constitutional violation or an evidentiary violation?
We certainly argue that it's both, and that this court in Pavone said that a defendant's silence after arrest cannot be used by the people in their direct case. But even if
I understand that in the sense of it all goes to an interrogation or a law enforcement presence, and you have a right to remain silent and you don't answer. And then we get into, well, should you have said something at that point, or are there unusual circumstances? But this really is, if this took place privately, if this call were taped by the person who had the restraining order here, and we had the same conversation, would there be a problem in admitting it?
I think that that would be a very different situation, and I think it is critical that the government was there. I mean, what the court talked about in Conyers and DeGeorge was the insoluble ambiguity of a defendant's silence, and that is at the fore here, because Mr. Vining was sitting under a sign that says your call is being recorded. When he picks up the phone, it says your call is being recorded. And he has been told, the district attorney's office even said in Johnson, that it blinked reality to assume that he has not been told not to speak on those phones. So he's making this call with the knowledge that anything he said is being recorded, can and almost certainly, given the volume of these calls, being turned over to the district attorney's office, and its attorney has told him not to speak about this case. So in this situation, you do have the insoluble ambiguity that was so problematic in Conyers and DeGeorge, and weighed against that is the prejudice, because jurors, was also noted in those cases, that jurors are not well equipped to weigh a defendant's silence in these situations, that they often will overweigh that. And so that risk of prejudice was very much here as well. And it should, going to respondent's harmless error argument, it also should be noted that this was not an overwhelming case of guilt, that the first thing that the prosecutor said after explaining the complainant's testimony was, I acknowledge she's a disaster, but this is not the only thing that you have to look at. The first thing that I want you to look at are these Rikers Island telephone calls, and the prosecutor used that as the evidence that the jurors could rely on to corroborate the complainant's account.
But there was other evidence that corroborated the complainant's account, too. Wasn't there, counsel, like the medical records that showed that her injuries were recent, not what your client was claiming, that some other person had inflicted those injuries on her at some earlier time?
What Mr. Vining said was that he did not know how the injuries were inflicted, that he speculated that maybe it was a prior boyfriend, there had been some overlapping relationship. But where there is only one witness to what happened, where this witness suffered, unfortunately, from drug abuse and schizophrenia, where the prosecutor's office turned over masses of Brady evidence that she had prior domestic violence incidents where she was the perpetrator against other individuals, and where she had other criminal charges involving violence, it can't be said that Mr. Vining was the only potential cause for her injuries.
Could I get back to one of the questions I think Judge Garcia asked? Are we to look at this categorically, or is it a case-by-case?
I think that, and I think it should be a categorical rule. That's the rule in DeGeorge and Conyers. This court found that categorically this is a class of evidence that should not come in. Whether there is some very unusual circumstance where the silence on a Rikers Island telephone call would come in, this certainly doesn't meet that standard, because the inference that is drawn here is that he was exercising his right to remain silent.
So just to be clear, the rule that you're suggesting, because again, in Conyers and George, we were talking about, interrogation. Your rule is that if a defendant knows that his or her call is being recorded by the government, that is equivalent to interrogation for purposes of
yes, that silence in the face of an accusation when the call is being monitored by the government, whether that accusation is made by the police or by a private individual, the invocation of the right to remain silent, or the exercise of a right to remain silent in that situation, should not be admissible as direct evidence of guilt.
Thank you, counsel. Counsel?
May it please the court, my name is Ross Mazer on behalf of the people. While the defendant was at Rikers awaiting trial, he voluntarily placed a call to the victim of his assault, violating an order of protection. The trial judge admitted a portion of that call as an adoptive admission by silence, and the trial judge issued the limiting instruction that was requested by defense counsel. So turning first to defendant's constitutional claim, that argument fails for two fundamental reasons. First, as your honors have already alluded to, private parties don't acquire a constitutional right to remain silent with each other just because law enforcement can overhear what they're saying. The Fifth Amendment is meant to ensure that defendants can't be compelled to talk to the police. But here, the defendant wasn't confronted with the police. In fact, law enforcement didn't do anything to elicit or induce any of the statements that defendant or VSR, the victim, made on the phone call. Recently, this court held almost as much in Johnson when it found that the Department of Corrections didn't solicit, elicit, encourage, or provoke the conversations from Rikers Island. Now,
But aren't they inducing silence? Because the reality is that he's informed, he's notified. You've all argued this, we've held this, you've given him a lot of notice. His counsel has told him that he's being listened to. So if he doesn't respond, he says, well, people are listening to me, I'm not going to say anything. Are you inducing that silence? Because that's really what, as I understand, the people have argued before, that this is the way they can avoid this information being used, which is just stay silent.
no, Your Honor, the law enforcement is not inducing the silence. In some cases, it may be true that a defendant is following his attorney's advice not to speak or trying to assert his right to remain silent, but it's certainly not true in this case. First of all, if his attorney advised him to do anything, surely it was to not risk a contempt charge by calling the victim of his crime in violation of an order of protection. More than that, he called the victim in order to dissuade her from testifying against him, and the only way he could do that was to talk about his case. In fact, in the call itself, we actually hear the defendant reference the fact that he might have to spend time in prison. So he was talking about his case. So under the circumstances of this case, I don't think the defendant was either.
So what if he had responded? Would it have been automatically inadmissible or admissible?
I'm sorry, if he had responded?
If he had responded, if there wasn't silence in the face of an alleged accusation that there was violence, and he addressed what she referred to in the conversation, what you did to me. I think she was referring to her ribs, right?
That he broke her ribs.
Right,
yes,
right. He was referring to the number of broken ribs. Would that have been automatically admissible or automatically inadmissible?
If the defendant confirmed the accusation, that would be admissible.
And what if he denied them?
If he denied it,
Then you wouldn't be using it.
no, we wouldn't be, Your Honor. Yeah.
I see. So does this create a rule then that requires that a defendant respond whenever an accusation is made against that person and the phone call is being monitored?
Different cases may present different arguments.
But let's stay with this argument, because this is what concerns me. Is a response required?
No, a response isn't required. This case is unique.
Okay, then if a response isn't required, then how are we not dealing with the right to remain silent? Simply because it's a police agency? Or not a police agency, I'm sorry.
Well, I think this is outside the right to remain silent. A response, this case is somewhat unique because it's the victim who's accusing him. And in most of the cases in which the defendant is accused by someone other than law enforcement, it's usually a co-defendant, or in this case, a victim, someone who was at the scene of the crime and knew what happened. But if a defendant was just talking to a family member or another relative, he's less likely to be in a position where that person is going to accuse him of anything since they weren't there when it happened, and that he'd be then in a position where he would have to deny something. So if a relative asked him a question or made a general statement, that doesn't seem to require a denial in the same way that an accusation does in this case. It also bears mention that most of the ambiguities that this court
Why
has...
not? Why, I'm sorry, I'm not following that argument. I get the point about the victim, but I'm not following why then, a fortiori, anyone else who alleges or who claims that the defendant, the person who's on Rikers, has committed this crime, that they wouldn't say, that not saying something isn't required. I'm not following that. Why are you less inclined to tell your mother, no, I didn't do this?
If another person leveled an accusation, certainly it would be the same situation. But if someone...
So in essence, then, anyone can interrogate this person, and then that can be then used against that person, the defendant, in any situation.
As you mentioned, As an evidentiary doctrine, certainly the people have to satisfy 3 threshold requirements before a statement can be admitted. We have to prove not only that the defendant heard and understood the accusation, that he was in a position to respond, but also that under the circumstances, a similarly situated person would have denied the accusation if it weren't true. And that requires a case-by-case balancing depending on the particular circumstances.
You made a point that he violated the order of protection by making this phone call. What if he had not initially intended to violate the order of protection? Let's say he had called, go back to his mother, but the victim happened to be there, and she grabs the phone and starts talking to him. Would you still be trying to use this?
As a constitutional matter, if law enforcement's only role was to overhear what was said, then the defendant's constitutional right to remain silent wouldn't be implicated. However, I do think that in this case, the fact that he did violate an order of protection, that he did voluntarily call the victim, those facts tend to undercut defense counsel's alternative argument that he may have been relying on his right to remain silent or following counsel's advice not to talk about his case. The last thing I would mention is that when the trial judge admitted the call into evidence, he issued a limiting instruction that was written by defense counsel. That instruction not only cautioned the jurors that they could afford whatever weight they thought was appropriate to the call, but it specifically enumerated the 3 innocent explanations that defense counsel thought were his best shot in that case. So it told the jurors to keep in mind, 1, that a person might remain silent because they understand they have no obligation to speak. A person might remain silent because of the natural caution that arises from knowing that your conversation is being overheard, or a person might remain silent because he thinks it's futile to try to respond in that situation.
Is it your position, counsel, that these are always issues that should go before the jury, that this goes to the weight of that admission, not its admissibility?
Absolutely. After the people satisfy those 3 threshold requirements, then any innocent explanation that the defendant may have to offer to explain his non-denial is a question for the jury to evaluate and goes to weight, not admissibility.
But it is a discretionary call for the judge in evaluating those factors, whether to admit it or not, as an evidentiary matter, right?
Absolutely, Your Honor.
So this would be an abuse of discretion review under that analysis.
Yes, it would. And
to go back to something that Judge Abdus Salam asked about earlier, there seems to be in this back and forth with the victim more than mere silence, particularly in response to one statement about "you broke my ribs," it's "so I'm a threat to you," language to that. So you think I'm a threat to you. I think your counsel for the defendant said that this was only submitted as a silence, adoption by silence. Is that right?
the trial prosecutor asked the court to admit the call as an adoptive admission by silence. But despite its name, that doctrine applies not just to silence, but also to evasive or equivocal responses. The significant factor as an evidentiary matter is just that the defendant failed to deny the accusation that was leveled against him.
So does the right to not incriminate yourself, I wasn't sure if that issue had been preserved.
Yeah, the constitutional claim in this case has been preserved, Your Honor.
It's fully preserved. Okay,
Counsel,
so
if we were to,
go ahead,
excuse me,
Judge. No, go ahead. Go ahead.
If we were to find that the admission of this recording was error, how do we get to a conclusion that it was harmless error?
Well, Your Honor, certainly if you excise the Rikers call from the case, there's no reasonable probability or possibility that the jury would have acquitted. For one, we know that the victim broke her ribs because we have x-rays and medical records, and the radiologist testified to that effect. We know that the defendant was with her at the time he broke her ribs, at the time she broke her ribs, because in a pretrial interview with the prosecutor, which was played to the jury and admitted as evidence at trial, he admitted that he was there, but he didn't have a good explanation for how else her ribs could have been broken. So a combination of her consistent testimony that her ribs were broken because he stomped on them, his placing himself at the scene of the crime without offering any innocent explanation.
He argued
the other
someone else
medical
did it at
evidence.
a different time.
I'm sorry, Your Honor?
He argued someone else might have done it at a different time. He's got other boyfriends or other people she's with.
It was something he said in the interview, but even by his own admission, the incident he was referring to with an ex-boyfriend happened several months earlier, whereas the radiologist in this case testified that she, because the fractures hadn't begun to heal yet, it meant that she had necessarily sustained them probably within the last couple days, but at a maximum, no more than 3 weeks earlier.
Too much time had elapsed. So let's say we agree with you on this question of the use of the Rikers call. Should the notice change at Rikers? Should it now say, and if you don't speak, that might be used by the DA?
I don't think this case would have an
You're
impact
usually
on that
monitoring
issue.
for what's said. You're trying to monitor, yes, for what's said, but what's missing in what's said, right? Should that also be, should the notice now have to be somehow modified to properly inform, if we agree with you, to properly inform those people who are detained at Rikers of the implications of the use of that phone and what they don't say or how they say it?
I don't think that a new warning would be required, and certainly it's not an issue that defense counsel raised below.
Thank you, counsel.
Thank you very much.
Ms. Knight?
Respondent refers to the fact that the government didn't deliberately elicit the statement. However, that refers to the Sixth Amendment right at issue in People v. Johnson. That's not the due process, Fifth Amendment fundamental right to remain silent that is at issue here. And the government really is minimizing the import of the surveillance of these Rikers Island telephone calls and how often they are provided to the district attorney's office. And I would direct the court's attention to Weaver, the GPS case. This court has always interpreted the New York Constitution in a way that reflects fundamental values and also changing technology. And these calls are being turned over en masse to the government. Even 4 years ago, over 10,000.
So if we agree with the people, what does that mean for defense counsel's advice to those on Rikers? Are they going to use these phones?
It really puts people in an incredibly hard position where, as Judge Piggott said in his concurring opinion in Johnson, that almost the only option is not to use these telephone calls at all, because anytime anyone brings up your case, which is very likely to happen when you're talking to loved ones, friends, potential witnesses, you either have to engage with them and risk that whatever you say is
The
going to...
defendant say, I can't respond to that, my attorneys advised me not to, and
Well, certainly under the
I
rule...
have to protect all my rights.
Certainly under the rule espoused by respondent, it's not even clear that that would be enough, because they're saying it's a purely civilian encounter and there's no protection, no Fifth Amendment or due process
If we
protection.
adopted your position, wouldn't people held at Rikers or any other facility just have to stop talking at all? Because if they talk about their case to, say, another person who's incarcerated, they risk that person being a snitch and trying to get a better deal. So how is, I'm trying to weigh in my mind what would be different if they didn't talk on the phone but they talked in person. What if Ms. R came to visit? I mean, not like, forget about the protection order, but she decided to come and visit him and they had a conversation and not on the phone, and then she then testifies that, you know, I accused him of breaking my ribs and he didn't say anything.
The language that the court has used is that a defendant's silence after arrest shouldn't be used by the people in their direct case, but I do think that it would be a very different situation if someone made this in a situation where there was no risk of government monitoring. I'm not saying that it should be admissible, but it is a critical and salient difference that someone who is sitting under a sign saying your call is going to be monitored by the government says, I'm not going to speak about my case. And I mean, that's what we have right here, and that's why his silence was so ambiguous, because it was perfectly consistent with the exercise of his right to remain silent in the presence of
Isn't
the
the
government.
key distinction that you're arguing is that you have government monitoring in a required response,
Yes, absolutely. And I think that putting forward a rule that makes it virtually impossible for people to speak on the Rikers Island telephone calls, which is really their only option, without grave risk of either saying something incriminating or having their silence be incriminating, is an untenable rule.
Thank you, counsel.
Thank you.